Proof of institutional knowledge and deliberate concealment. Recitals. Whereas the complainant is the individual submitting the evidentiary and factual materials as detailed herein. And whereas the Ottawa Police Service is the law enforcement institution charged with investigation and enforcement responsibilities related to the matters raised by the complainant. And whereas the Crown Prosecutor's Office represents the public prosecution authority entrusted with ensuring lawful and fair criminal proceedings. And whereas Michael Broughton is a party involved whose actions and communications are pertinent to the institutional conduct examined herein. And whereas these parties collectively bear distinct roles and responsibilities that intersect in the investigation, prosecution, and adjudication of the matters alleged by the complainant. Now therefore, this document presents an analysis and proof addressing alleged systemic failures, misconduct, and concealment involving these parties expressly for purposes of Canadian legal examination and redress. Definitions. For the purposes of this document, the following terms shall have the meanings assigned to them unless the context otherwise requires. Complainant means the individual submitting the evidentiary and factual materials as detailed herein. OPS refers to the Ottawa Police Service. Crown refers to the Crown Prosecutor's Office or representatives thereof involved in the subject matter. Institutional knowledge means awareness or possession of information by institutions or their officers that is pertinent to the matters described. Deliberate concealment means intentional withholding, suppression, or misrepresentation of relevant information or evidence. Misfeasance in public office refers to a public officer's malicious or reckless conduct in the exercise of official powers recognized under Canadian common law. Obstruction of justice refers to acts that unduly interfere with the administration of justice as defined under Canadian criminal law. Malicious prosecution means the improper and unjustified initiation or continuation of legal proceedings. Preamble. This proof document encompasses an analysis and presentation of evidence related to systemic failures, active suppression, and legal infractions including misfeasance in public office, obstruction of justice, malicious prosecution, abuse of process, and infringement of charter rights. It compiles documented evidentiary submissions from the complainant, official communications from the OPS and the Crown, recorded admissions confirming collusion, legal authorities and case law applicable to the misconduct. 1. Knowledge plus inaction equals misfeasance in public office. 1.1 Factual submissions and evidentiary package. The OPS received comprehensive and credible evidentiary packages from the complainant, comprising video recordings, forensic briefs, time-stamped legal correspondence, third-party witness corroborations, and direct acknowledgments of receipt by officers. On April 7, 2025, an email from OPS explicitly acknowledged receipt of 7 separate emails containing incontrovertible video or written documentation proving her innocence. Despite this knowledge, the official report concluded with no further action. 1.2 Officer conduct and deliberate disengagement. Detective Jessica McFadden, designated lead officer, expressly refused to engage further, responding with the statement, "I am not going to correspond with you over email. Currently I have grounds for your arrest." This explicit acknowledgement evidences knowing possession of critical exculpatory evidence coupled with deliberate inaction constituting misfeasance in public office under Canadian jurisprudence. 2. Suppression of exculpatory and contextual evidence amounts to obstruction of justice. 2.1 Crown disclosure violations. The Crown's official disclosure replaced the complainant's original comprehensive and structured evidentiary submissions with incomplete fragments, screenshots lacking headers and metadata, and selected excerpts omitting full context. This conduct contravenes established case law, including R.V. Stinchcombe and R.V. Hirsch, which govern the Crown's duty to disclose all relevant information, including exculpatory evidence, to the defense. Metadata removal and truncated communication threads impaired the defense's ability to verify authenticity and contextual integrity. 2.2 Removal of critical context. Both OPS and the Crown deliberately removed reports evidencing coercive control and psychological abuse, medical documentation related to the complainant's disabilities, evidence demonstrating lawful and non-threatening communication attempts. These acts constitute active suppression of evidence, therefore fulfilling the legal definition of obstruction as they interfere with the administration of justice. 3. Refraction and decontextualization of evidence to alter perception. 3.1 Use of pejorative characterizations and narrative conditioning. Instead of objective inquiry, institutional actors utilized stigmatizing terminologies, such as rambling, messy, difficult. These descriptors were intentionally applied to reframe credible trauma responses as proof of mental instability, thereby prejudicing official assessments and judicial outcomes. The official record explicitly notes this practice is not oversight, it's conditioning, reflecting intentional narrative manipulation. 3.2 Inclusion of defamatory and irrelevant material. The Crown's disclosure further included defamatory imagery, such as a photograph sourced from Broughton's website, unrelated to the substantive issues. Irrelevant references regarding the complainant's residence, mention of a deceased individual to skew perception, mischaracterization of draft court motions as doctored, when in reality they were unfiled preliminary drafts. 4. Michael Broughton's knowledge and manipulative conduct as institutional evidence. 4.1 Pattern of psychological violence and legal manipulation. Michael Broughton's communications and forensic analysis of the evidence demonstrate a calculated strategy involving manipulation of reporting mechanisms, deployment of legal complaints and criminal allegations as tools of psychological violence, false claims relating to theft and break-and-enter offenses. 4.2 Knowledge and concealment. Mr. Broughton knowingly submitted false allegations, despite clear evidence of lawful ownership. Ops intentionally failed to act on documented serious incidents dating back to 2018, including threats, stalking, sexual assault, and illegal surveillance. The 2018 case file remained inactive for years, exemplifying institutional neglect. 4.3 Recorded admission confirming systemic collusion. A recorded statement by Michael Broughton that the police won't do anything emblematically confirms his confidence in institutional protection, consistent with repeated past experiences and systemic collusion among all parties. 5. Institutional misconduct across all actors, Ops, the Crown, and Broughton. 5.1 Interrelated omissions and affirmative acts. The following systematic coordination is evidenced. Ops reclassified reliable direct evidence as rambling, thereby invalidating submissions. The Crown proceeded with charges premised on this distorted evidence. Mr. Broughton's falsified materials were accepted without scrutiny. 5.2 Mutual silence and reinforcement of false narrative. Each institutional actor's failure to correct or disclose critical facts created a self-reinforcing cycle enabling ongoing wrongful prosecution and public misrepresentation, amounting to institutional gaslighting. 6. Legal implications and jurisdictional authorities. 6.1 Malicious prosecution. Pursuant to Nels v. Ontario 2 SCR 170 and a fixed jurisprudence, initiation of legal proceedings without reasonable and probable cause, in the presence of exculpatory evidence, for improper purposes, constitutes actionable malicious prosecution. 6.2 Abuse of process. Aligned with Miazgovic Velo Estate 2009 SCC 51, the manipulation of the legal process to perpetuate private wrongdoing or intimidation is strictly prohibited and actionable. 6.3 Misfeasance in public office. As established by common law, the deliberate performance of a public officer who, knowing their act to be unlawful, intentionally or recklessly causes harm, fulfills this torts criteria. 6.4 Charter rights violations. The conduct described herein transgresses multiple rights under the Canadian Charter of Rights and Freedoms, including but not limited to Section 7, Right to life, liberty and security of the person. Section 9, Protection against arbitrary detention or imprisonment. Section 11, Presumption of innocence until proven guilty. Section 15, Equality before and under the law, protection against discrimination including based on disability and survivor status. 7. Foreseeable and proven harm to the complainant. 7.1 Loss of family and support systems. The failures and omissions precipitated loss of contact with the complainant's children, loss of custody and care over the family pet Moji, diminution of essential emotional and social supports. 7.2 Death of Donald Blair. Ops ignored a 911 emergency call relevant to Donald Blair, whose subsequent death could reasonably have been prevented by timely police intervention. 7.3 Deterioration of health. Stress and trauma arising from the institutional mismanagement directly accelerated exacerbations of the complainant's chronic obstructive pulmonary disease and overall health deterioration. 7.4 Criminalization and financial destabilization. Instead of protection, the complainant suffered criminal charges with accompanying legal, financial, and emotional repercussions, undermining stability for years. 8. Meaning, evidentiary conclusions, and affirmation of institutional complicity. 8.1 Confirmation of knowledge and strategic suppression. The reoccurrence of identical evidence, albeit mischaracterized and mutilated in official disclosures, inherently proves possession, awareness, and deliberate decision to conceal and misrepresent by all platforms, active suppression rather than innocent error or negligence. 8.2 Systemic silence and collusion. The conduct evidences a decade-long pattern of silencing a victim through procedural and evidentiary mechanisms, reframing credible evidence to discredit and punish, prosecuting a complainant for the consequences of state neglect and institutional abuse. 9. Severability. If any provision of this document is found by a court or competent authority to be invalid, illegal, or unenforceable in any respect, the validity, legality, and enforceability of the remaining provisions shall not in any way be affected or impaired. And the offending provision shall be severed to the extent necessary to give effect to the remaining provisions.
Why didn't you ease up on me then? Why didn't you stop? You can even imagine, based on how you remember feeling when you did it, so angry and I know that. That you were conspiring with a psychopath to do it.
That day stuff, it's etched in my brain, and it's something I...
Oh, your brain?
Yeah, mine too. And it's something that I'll sorry, I'm not trying to compare myself to you on this, but...
You could never know.
I know.
And you didn't just do that to me. You were doing it to my children. And with you and your fucking psychosis, but nobody to keep you in check? And her around and nobody to protect those children? Then why were you trying to kill me? The truth. Why were you trying to kill me?
Just so wrapped up in the misery that I've made for myself, and you were the target of everything, and it was the ultimate fucking punishment to put on you, I guess.
You knew I was invincible.
Yeah, I did.
With two small children.
I've never wanted to hurt anyone more than Harry right now, bitch. I'm gonna enjoy every fucking minute of it. Who obviously would have liked to be beaten to a pulp.